Welcome everyone to another episode of the Law and Governance program. This is a program that is usually conducted audio only. This is our first time with a video recording, but substantively, like before, we are talking about public law issues, whether scholarship or in this case, a new decision by the Supreme Court. We'll be talking about the Supreme Court's recent decision in Loper Bright versus Raimondo, which of course overruled the Chevron case. This has been a huge item of discussion among administrative law professors and the wider public for the last few days. There was another decision that the Supreme Court issued yesterday that has maybe taken even more public discourse, and that is not something we'll be talking about today, but I think it's at least worth mentioning that this has been a very maybe consequential few days of Supreme Court decisions. We will be going back to the one that, at least as administrative law scholars, we were most focused on earlier this week. I should mention that this program is co-sponsored by the Penn Program on Regulation, directed by Cary Coglianese, who you see on the screen. Thanks, as always, to Cary for hosting the series generally, and for today hosting our webinar or our video version of the show. Why don't I invite everyone, starting with Cary, to introduce themselves, and then we'll get going in our conversation.
Well, thank you, Neysun. Delighted to be here. I'm Cary Coglianese. I'm on the faculty at the University of Pennsylvania, where I direct the Penn Program on Regulation. Very pleased to sponsor this terrific series that you organize. And let me offer my thanks to all the wonderful colleagues who you've recruited to be on the call today. I'm very much looking forward to our conversation.
Bridget, do you want to go next?
Sure. Hi, everybody. Bridget Dooling. I'm a law professor at Ohio State, and I'm only mildly resentful that I had to be camera ready for this one, Neysun. I really did like the audio only one.
Emily.
Hi, I'm Emily Bremer. I'm a professor at Notre Dame Law School.
Michael?
My name is Michael Herz. I'm a longtime administrative law professor at the Cardozo Law School.
And Kristin?
Last but not least, I'm Kristin Hickman from the University of Minnesota Law School, where I'm a professor and associate dean for faculty and intellectual life as of yesterday. Oh. And I have to disagree with Bridget. I like being video. I think it's great to see everyone.
It's nice to see everyone, yeah.
It is very nice to see everyone. Everyone looks great. And it is such a terrific group of people to have this conversation about. It is only a few days since the decision came down, but of course it's dominated discourse among administrative law scholars and practitioners for the last few days, and at least until yesterday was dominating a lot of public discourse about the Supreme Court as well. And just, I thought it'd be interesting to start off with just all of your, broad reflections on this moment for administrative law. What does it mean when a decision like this, which upends maybe, and we'll get into that over the course of our conversation, long-standing approaches, when a decision like this comes down and scholars are trying to figure out how they're going to teach it, what are the implications for their courses, when lawyers are trying to figure out how they're going to recraft their briefs, when judges are thinking about how they're going to recraft their opinions, how special is this moment in that broad sense and all of your views?
I think it's a wonderful opportunity from a teaching perspective to be able to model for our students what the real world of legal practice is like. Practitioners, whether they're judges or in-house or lawyers in law firms or in government, frequently are having to deal with changes in statutes, in regulations, in cases, in real time, in a moment where everyone is looking around and saying, now what? And so you can communicate that to students and say, well, what do you think? What would you do in this position? So it's exciting as a professor anyway, as a teaching opportunity.
Do others share the excitement?
I agree. Sorry. Go ahead, Michael.
I defer.
I mean, I agree. It's a jolt to the system, as Justice Kagan says in her dissent. She doesn't mean it as a compliment. But I do think in legal practice, usually you're focused on a relatively narrow area. And so decisions that are maybe not significant to the entire nation are significant to your legal practice. And I mean, those can be hard to communicate to students in a classroom setting, right? Like trying to impress upon them, you have to a lot of times spend a lot of time just convincing them that a new decision is important. I think we will need no time whatsoever to explain to students that this is a major sea change. They'll get it immediately in a way that really, I think, opens up opportunities to have a real conversation about like what now. And sometimes I think it's good to remember that everything we do, we all in our own sort of maybe narrow corner of the legal profession have a role in shaping what comes next. And the opportunity is so obvious here that I think maybe we can all have an express conversation about how we contribute to what comes next in a way that is positive. And I'm hoping that the dialogue will soon turn more towards that as opposed to sort of upset about the change.
Michael, you were going to go next, and I want to kind of put in an additional question for you. You might have the longest kind of time frame of everyone here teaching administrative law, and I just
very
wonder
very
if,
delicate way of
I tried to be. So the question I want to ask
long
is,
time frame.
are you at all amazed that so many people in the wider public even know what Chevron is? Like, if you go back and think, for most of the last few decades, if you threw a stone out and asked someone, have you ever heard of Chevron? They probably would say no. Is that in and of itself kind of interesting that it's become this this part of maybe in our world huge but otherwise arcane part of Supreme Court jurisprudence is now on everyone's lips?
No, it is remarkable. Remember when Meade came down? So my background. See, this is because I believe in transparency. I want everyone to realize I'm not actually in my office, and I've fixed it 9 times but failed to do it completely. I'll do something in a second. So remember when Meade was decided, and Justice Scalia, who back then was, the most violent or ferocious. Violent is too strong a term. Ferocious supporter of Chevron on the court. He wrote this very upset dissent and about the avulsive change, and it was picked up by the Washington Post, which had an editorial, an anti-Meade editorial, or at least an editorial about Meade, and that just seemed astonishing. Right? That the niceties of Chevron doctrine would show up in the editorial pages of the Washington Post, right? Inconceivable. And yet here we are, where Loper Bright is all over the editorial pages and all over the blogs. And yeah, it is a unique moment. I think that, I have 2 reactions to it. One is, and we'll talk about this later, I think Loper Bright is less important than, a lot of the hysterical stuff in the popular press and on the internet suggests. I think it's not fully understood by lots of people who are upset by it. But there's a way in which there is a fundamental truth to all the attention it's getting, right? The niceties are maybe somewhat misstated, but it is a really important time. Something big is going on. It's not just Loper Bright, and it's not as, to use Scalia's term, avulsive as it might have been, right? If the CFPB case had come out the other way, if Jarkizi, if they'd actually agreed with all 3 of the reasons the Fifth Circuit gave, not just the one, if you roll all these things together, it could have been a more dramatic term, but it is absolutely a fundamental shift taking place, and this is why it's appropriately, in the public sphere, a fundamentally anti-administrative shift is taking place at the Supreme Court. That's just undeniable. They trust agencies much less than historically the Supreme Court has. They trust the president more than agencies, and they trust themselves more than the president. And that's the basic shift that's absolutely taking place.
Can I build on that and say it's interesting to me that yes, this is in the public dialogue more than most administrative law decisions have ever been. But it's also interesting that I think in the public discourse, many people are referring to the decision that the court undertook on Friday as the Chevron decision rather than as overturning Chevron. But as to build on what Michael was saying, I think I think about this as someone who recognizes that administrative law has often been in flux. I mean, we all know that. Every year in teaching administrative law, we have to do some modification of our syllabus in ways that are probably our colleagues who teach contracts or torts don't have to do. There's substantial flux. But I think about this in the same terms that Bruce Ackerman referred to, sort of, different kinds of constitutional change. And he distinguished between sort of the ordinary constitutional evolution that occurs in a system of constitutional common law from those very high constitutional moments. And I think we're in at least with respect to administrative law, a high moment in administrative law in which this Supreme Court, whatever one makes of the actual doctrinal niceties of Loper-Bright versus Chevron, it's very clear that by saying one of the most widely cited administrative law decisions of all time, to say Chevron is overturned, that's a dramatic statement. It has tremendous symbolic import, and I think that translates into symbolic power that, as Michael said, that is transferring to the judiciary and signaling that lower courts and other and future Supreme Courts are going to be taking a much more muscular approach to deciding administrative law cases.
And just before going over to Bridget, I think we've already kind of, in all of your comments so far, we have sort of, three different terrains already marked out for discussion. One is just the doctrine, but then there's also the broader atmospherics, going to what Michael was alluding to, but then also how this actually plays out on the ground. And I think over the course of our conversation, those three terrains will all be interesting to explore. But Bridget, do you want to weigh in on this initial question?
Yeah, and of course there's a helicopter passing overhead just as you come to me, so love that for our audio listeners. I mean, I think the only thing I would add to this already really rich conversation is that I think at least, I won't speak for everyone here, but I was surprised that Chevron was fully overturned. I expected a more incremental change, I would say. And I think we had reason to expect that, right, given what has happened in other cases in the last few terms. So, yeah, I mean, I think that's an element of this. And when I think about, how I want to approach the coming months and years, it's with a version of what I would call alert humility, right? So I want to be watchful. I'm going to call for, as we get deeper into this, so we need people tracking this, bringing data forward, helping us understand, how this is all evolving. And then I think we have to do our process of reflection and sort of putting it through, its paces and thinking about it. But I was sort of astonished by the number of people who had like quick, rapid takes on the overturning of Chevron, because from my perspective, it's such a fundamental shift that I'm honestly not sure what's going to come next. And so if I would want my students to take away something from me in this time period, it would be this sort of alert and attentive humility ultimately, and trying to really be watchful and in conversation and trying to really understand, what's happening, and at the same time, occasionally applying pressure in the direction that I would want the field to go and the way that I'd want analysis to go, also like all advocates do. So legal advocates anyway. So anyway, that's kind of where my head's at in terms of, any additional part that I would add to what my colleagues have already shared.
And Bridget, that's so beautifully said. And I think it's a good theme for our discussion because the opinion came down, I guess, Thursday, right? Roughly Thursday. Today is
Friday.
Friday, so even sooner. And today's the following Tuesday.
Hey.
We are not, the first blog post that went up after the decision, but we are still relatively early. And I think that theme of humility probably is one that all of us will ascribe to in this conversation. And the point of this discussion is not to say that these are the conclusive views for all time, but at least a few days after this, landmark decision, trying to grapple through it a little bit together collectively. But I'm sure if we did the same conversation 6 months from now, a year from now, 2 years from now, everyone would have, slightly different things to say. Okay,
If I
so
can add one thing
of
quick,
course.
Neysun, I want to say one thing. I agree with Cary that this is a high moment in administrative law. It's a very symbolic moment. Loper Bright, Corner Post, all of these cases are really important cases. But it's not the first high moment or symbolic moment in the development of the law of this country. One of the things that I find very frustrating is reading all of the commentary to suggest that somehow this decision is unique in its import and, uniquely either cataclysmic or, some people are speaking in terms of euphoria, but either way, we've had big shifts before and the Republic hasn't fallen. So, I am hopeful, I think the point was made that hopefully we will, as we go forward, we will start to focus on where we're going rather than lamenting where we are in the immediate moment or what we have ostensibly lost.
Very good. Very well said. And I think we've basically telegraphed for our audience all the different themes we're going to be discussing over the course of the next hour or so. Many people who watch this will, of course, already be quite knowledgeable and expert about this overall legal terrain. But even for them, I think it's still useful to just start off with, a little bit of common consensus over what is the terrain of law that we're talking about and what was the state of play before this consequential decision on Friday. And I can think of no one better to lead us through that than Michael. So let me ask Michael to go first and, just set up for us a little bit how we should be thinking about what was the state of law on judicial deference to agency interpretations of law as of Thursday.
Okay. Easily stated. Shouldn't take more than 2 or 3 sentences. If it's okay, I'm going to back up a little further because, as you said, I'm the one in this group who's cuddled up to Chevron for the longest, so in part, I don't know if you realize this, Neysun, but I assume that you've asked me to do this because I don't want to brag, but I was actually clerking in February of 1984 at the United States Supreme Court. So I was there at the creation. So I have a lot of pretty unique insights to share, having been, right there at the moment. So let me lay some of those out for you as someone who was there. Yeah.
And who were you clerking for, Michael? Just a way of background, if you...
I was clerking for Byron White, so not Stevens. I got nothing. Can't remember the case. Truly cannot remember it, okay? I assume like it was not my case, but maybe I was the clerk in the White Chambers who worked on it. Who the hell knows? Just no idea, right? No idea, which is just one way of confirming what has been disputed over the years, but I think now is the standard story. And I think is absolutely right that the court had no idea and Justice Stevens had no idea that he was in any way transforming the law. This was not a revolutionary decision. 3 justices were recused, right? There were only 6 participating. You don't revolutionize the law when you're 6 justices. No one concurred, no one dissented. If you're revolutionizing the law, somebody says something, right? It's the dog that did not bark. And the whole style of the opinion is just telling you what we always do. This is a run-of-the-mill case, complicated statutory question. Ugh, go with the agency, right? And Chevron only became Chevron later. Gary Lawson has written a very good article charting this out. And when it turned into Chevron, it felt a little different than it does now. So I want to just share my screen for 1 second to read you 4 quotes about Chevron. These are all from people you've heard of. We join Chevron's critics. From the perspective of the original constitutional design, aggressive judicial review of agency rulemaking ameliorates the constitutional dilemma under which the modern administrative state has witnessed a shift of lawmaking power from Congress to the president. 2, the danger of Chevron's song lies in its apparent obliviousness to the fundamental alterations it makes in our constitutional conception of the administrative state. It is surely a far more remarkable step than Chevron acknowledged to number among Congress's constitutional prerogatives the power to compel courts to accept and enforce another entity's view of legal meaning whenever the law is ambiguous. 3, Chevron suggests that administrators should decide the scope of their own authority. That notion flatly contradicts the separation of powers principles that date back to Marbury and the Federalist. 4, the judicial power as originally understood requires a court to exercise its independent judgment in interpreting and expounding upon the laws. Chevron deference precludes judges from doing so. It thus rests from the courts the ultimate interpretive authority to say what the law is. See Marbury v. Madison. So who wrote those 4 things? They are respectively Bill Eskridge, Cynthia Farina, Cass Sunstein, and Clarence Thomas. Right? The usual 4 like-minded quartet of Chevron critics. We know that this is their stance. And the point, of course, is that when Chevron first turned into Chevron, which wasn't 1984, it was 1988, 89, 90, it was deeply suspect on the left and completely and enthusiastically embraced on the right. All the Chevron enthusiasts were on the right. Judge Starr wrote a famous article. Judge Silberman wrote a famous article. There was an ABA-sponsored roundtable of, Ron Levin moderated, Cass Sunstein and Alan Morrison were the 2 huge Chevron skeptics, very down on Chevron. And Ken Starr, then Judge Starr, and Richard Willard, who was in the head of the civil division in the Reagan administration, were the 2 Chevron enthusiasts, right? It was just a wholly different world. And I stress this partly, it's relevant to what happens when Chevron goes. It's just a reminder that if Chevron's taken seriously, it empowers agencies. What agencies do depends on who the president is. And whether you trust agencies or courts depends on who's in the agency and who's in the courts. And at that time, it was the Reagan and first Bush administrations. There were a lot of Democratic appointees in the judiciary. The environmental groups. Indeed, in the late 80s, I was working for the Environmental Defense Fund. Everything I'm going to say is just going to be like me and Chevron. Okay, I'm going to bore you with my own personal journey with Chevron. I was working at EDF and we hated Chevron, okay? Because we thought that we were losing cases against the Reagan EPA on issues that we had won in Congress, and courts and the agency was ignoring the statute and the courts were letting them get away with it, right? So what happened after that was, over the years, one noticed actually enthusiasm about Chevron flipping on both the left and the right, depending on who the president was, not surprisingly, right? And so it's kind of like Republican presidential candidates really like the REINS Act, but once they become president, it doesn't look so good anymore. And so when you're the president, Chevron sounds good to you. If your guy is in the White House, Chevron sounds good to you. If your guys are in the courts, Chevron looks worse, right? And what is so interesting in the overall history of this is that that sort of flipped repeatedly. And then, so during the second Bush administration, you know, there was no talk on the right of getting rid of Chevron, or very little. A lot of talk on the right about getting Chevron once Obama was president. A lot of new enthusiasm for Chevron on the left once Obama was president. And then Donald Trump becomes president and nobody flips. Everybody sticks to their position, because by then, people had decided, I mean, there are a few things going on. One is just, you know, everything's a little different when Donald Trump is president. Another is that people become a little more wed to their positions. There's more of a paper trail in the age of the internet and so on. But the other thing is, I think both sides decided, and I think rightly so, that overall and on the whole, Chevron is a pro-regulatory doctrine. Okay, not there'll be a million individual counterexamples, but overall and on the whole, because agencies tend to like to do stuff. They tend not to like to undo stuff. They tend to want to have, you know, secretaries want to have something to show for their tenure. People go to work in agencies because they believe in regulation and so on. So overall, so what led up to Loper was a kind of 8-year period where views really cemented. They stopped flip-flopping. And the right was just firmly against Chevron, and the left was wildly enthusiastic about Chevron. And the role, you know, what it, the post-Chevron, immediate post-Chevron politics had totally flipped. So why would this all happen? Now I'll actually answer your question, Neysun, sorry, but just in 2 words, you know, what Chevron does is to, if read strongly, another little parenthesis, you know, Chevron's overruled, but it's not quite clear what Chevron was. And there's, you know, that's continually debated. But it sends us, read strongly, what it says is, when somebody challenges something an agency has done as being inconsistent with a statute, everybody understands the statute controls. Agencies are creatures of statute. They only have whatever authority the statute gives them, and they're subject to whatever limitations the statute imposes. So there's always going to be a potential question of whether the agency has acted consistently with the statute. The agency asserts that it has, by definition. That involves an interpretation of the statute. Challengers say the agency misread the statute. What it did was inconsistent with the statute. The court then has to interpret the statute. The APA, Administrative Procedure Act, tells the court to decide questions of law and interpret statutory provisions. And this is an important check on agency error and overreach. The court is there to enforce Congress's decisions as expressed in the statute. But what does a court do when it's just not sure what the statute means? And there are basically 3 alternatives. Oversimplifying, it can just make its own decision. You know, treat it like a constitutional case. Courts don't defer to anyone deciding the Constitution. You decide what the statute means. Second is to take seriously the agency's views in some way. You know, what way exactly we can debate, but it matters what the agency said. But the agency's views don't control. Ultimately, it's a judicial decision. And the third is to say, well, just go with the agency, right? They know more than us. They're politically accountable. Congress may want it this way. We'll go with the agency. And the strong view of Chevron, the strong reading of Chevron, is to say that where the statute is unclear, how unclear, who knows, but it's unclear, the agency has not acted bizarrely. It's not nuts. It's reasonable what the agency has said. Just go with the agency. And that is at least that much has been clearly reversed by Loper Bright. The last thing I'll say, sorry for going on so long. In Loper Bright, the Chief Justice described Chevron in what was surely meant as a quotable soundbite. So now I'm quoting it. a decaying husk with bold pretensions, right? That just there was nothing left. Now, of course, that's what you say when you reverse a longstanding case, right? Nothing to see here. It's already dead. We're just making it official. There's always been a big dispute about how important Chevron has been. How much difference does it make in the real world? But it's absolutely true that, first of all, it never made much difference at the Supreme Court. And second, by last Thursday, it no longer made any difference at the Supreme Court at all. So in terms of where did we stand before Loper Bright, at the Supreme Court, Chevron was an irrelevant and meaningless doctrine. In the lower courts, it still mattered. And the way it basically worked was to, again, shift more power that might otherwise be placed with the courts to the agencies. Agencies could do more. They were freer to act. How much? A matter of huge debate.
That's fantastic. Thank you, Michael. It's, both a very clear statement of kind of the state of play at the end, but also lovely kind of historical context for how we got there. And I want to give everyone a chance to kind of just, riff off of Michael's comments. But two things I wanted to especially draw out. This point that Michael made at the very end, that even as of Thursday, there was a difference between how Chevron was being applied at the Supreme Court and the lower courts. And I think that that's just an important kind of thing to keep in mind, that maybe Chevron was already dead at the Supreme Court for a long time, but had some vitality still at the lower courts. And the second thing is, I think Michael correctly kind of captured the political dynamics over the last few decades, and this sense that with respect to, yes, there's going to be complications here and there, but on the whole, Chevron seems like a pro-regulatory doctrine. And if you have this rising antipathy towards the administrative state, you might not like that. But I'm also curious if, aside from just the political shifts, whether the increasing doctrinal complexity of the wider Chevron framework with Mead and Brand X, Cary's written about kind of the step zero problem and how that maybe led to this environment that made it easier for Loper Bright. I wonder if someone wants to also, maybe Cary, if you want to pick up on that, if that is part of the story here too, that even as of Thursday, we weren't at maximum Chevron. We were at a much more complicated overall landscape, and maybe that made it easier to say that this is a decaying husk that needs to be put aside.
Well, I'll just be brief because I want to hear from others too, and just say that I think there's a difference between Chevron in practice, Chevron as a doctrine, and Chevron as a symbol. And really, Michael's account, I think, shows so well how Chevron as a symbol has really grown up tremendously. And I think Loper Bright now is making a very bold symbolic move, telling especially lower courts that their role needs to change, and that may have some effects in practice too, even if ultimately Loper Bright isn't fundamentally changing the doctrine a whole lot. I would also say there's nothing that that in a world with Chevron or without Chevron that makes statutory interpretation any easier or harder. So this is there's always going to be a perennial challenges about how to understand statutes, and particularly how to understand what weight to be given to the government's views about what a statute means. And I think with or without Chevron, there will be advantages that the government position probably receives in court. But I think as a symbol, it really has grown up, and in some ways, I think it's unfortunate that the court has sort of played into by overturning Chevron rather than what we might have called before last Thursday, Kaiserizing it, or somehow modifying or clarifying it without overturning. But I think the words Chevron is overturned were really a bold symbolic gesture, and that just sort of puts the court right squarely in the middle of Chevron as a symbolic politics dispute, and here we are.
Yep. My thoughts were basically exactly the same. I mean, I have always sort of distinguished between Chevron the case and Chevron the doctrine, by which I mean like what lower courts and maybe also agencies actually do with Chevron. And I kind of read Loper-Bright as responding less. I mean, it says it overrules Chevron, but I think the target is not actually the case, but what lower courts and maybe agencies have done with the doctrine that case created. And you know, I also was sort of hoping for a Kaiserization of Chevron. I read Justice Kagan's opinion. A lot of it sounds awful familiar. If you are familiar with Kaiser, it reads like it started off as maybe a bid towards a majority opinion. But you know, if the court was trying to really jolt the system out of the ruts of Chevron and into a different framework, maybe a Kaiserization wouldn't have accomplished that goal. And I can't help but think of sort of two things here. One is Bridget's, I think, very sound advice to sort of wait and see what happens, because just like there was Chevron and what courts did with it, there's Loper-Bright, and then there's what courts will do with it. And we won't know really what the effects are until we have some time to see what those effects are. And then the other thing that it has in mind for me, and this comes back to what Cary was saying about the sort of symbolic, I think, nature of Loper-Bright, actually reminds me of some Kristin's work on the non-delegation doctrine, that maybe the symbolic sort of weight of Loper-Bright is the thing that the court was trying to accomplish that it couldn't have accomplished through Kaiser, and just the threat of, no, we're going to interpret statutes, this is our business, might actually be an important sort of message to the system. And given that the court takes, I mean, it's fewer than 80, isn't it like 60 something cases a year? I mean, it's crazy. Like, the only way you can control, to the extent that you are actually controlling anything that happens in the system below the Supreme Court, you can only do it through big, loud, symbolic moves if you're going to take so few cases. And I'll be interested to see whether it works. I mean, it didn't really work with Chevron, right? The court didn't really think it was doing anything, and it tried to like take it back in some cases after Chevron, and it failed. And now it's like, I mean, as a parent, I can't help but feel like this is like when I ask my kids nicely, and then I ask them like a little less nicely, and then they're still not listening. And so I get a little loud, and like, I kind of feel like the Supreme Court has just gotten to the point where like it's yelling at the children. And I will be interested to see whether that works better with the lower courts than it works with my kids.
I do think there's something interesting here, though, about how doctrine evolves. You know, I was anticipating a Kaiserization of Chevron as well. And I will say it's been interesting if you look at post-Kaiser case law with respect to agency interpretations of agency regulations. Kaiser has had the effect of dramatically shifting the amount of deference and the way that lower courts are approaching those sorts of cases. But I do think with respect to Loper-Bright, maybe they felt, in answering your question, Neysun, that sort of reset was not going to work with Chevron. I mean, I do think that the evolved complexity of the Chevron framework contributed dramatically to why the court might have overturned Chevron outright. You know, when Scalia was advancing his version of Chevron, he envisioned, it's quite clear, a fairly straightforward, simple to apply rule. You know, yes, a robust step one employing traditional tools, but then irrespective of what format the agency was using to advance its interpretation, you know, a highly deferential, the court described it in Loper-Bright as mechanical deference at step two. You know, Scalia liked bright line rules. He didn't like mushy standards. But you add in, the actual application of Chevron in the lower courts was so much more complicated than that. And it was really, really clear that the justices simply couldn't agree even on something as simple as how clear is clear, what step one entailed, which tools of statutory interpretation they ought to take into account, how quickly they ought to get to step two, and what step two then entailed. So you had Mead and Brand X and all of the different cases talking about scope issues. You had the complexity around Chevron step one, and because the justices themselves could not coalesce around a single vision of what Chevron represented, that left a lot of latitude in the circuit courts and the district courts for a real range of approaches to how Chevron gets applied in a way that I think really troubled the Supreme Court at the end of the day. So they decided to throw out the baby with the bathwater and start over symbolically. It's not entirely clear how much they're starting over. If you really drill down into the Loper-Bright opinion, not only are we keeping Skidmore, it appears, but they have a couple of carve-outs for applications of law to fact, or mixed questions of fact and law, that is. But they also have this carve-out for express delegations that clearly convey discretionary power to engage in policy making to an agency. And at least, if you sort of at which point there's counseling arbitrary and capricious review, which is highly deferential. And so if you really break down Loper-Bright, there is at least a way that you can arrange Loper-Bright so that it looks not all that different from at least some conceptions of Chevron. So I think it's really important to see how this is going to unfold in the lower courts, whether we're really going to get, the kind of robust statutory interpretation by courts that Loper-Bright seems to counsel, or whether the lower courts are going to catch on to this express delegation of, or clear delegation of policy-making discretion language and the arbitrary and capricious review standard in Loper-Bright, and start finding, those sorts of delegations in the statutes, at which point the line between policy making that gets deference and statutory interpretation that doesn't, the line may have shifted a little bit as a result of Loper-Bright, but how much it shifted may be a really open question.
And that's
Kristin
great,
didn't-
Kristin. Oh, go ahead, Michael.
I just want to, Kristin didn't mention it, so I will, that she has an article called Chevron's Inevitability, which kind of suggests that courts will never fully get away from deferring in some form or another. The details and the vocabulary will change, but there is a kind of inevitability here. And then Kevin Stack has a more recent article called Chevron is a Phoenix that is sort of consistent with that view. And I think it's exactly right that courts have been deferring somehow or other for a long time, and they will continue to do so.
I just wonder if maybe, with apologies to Kristin, if those two titles should have been rephrased, Skidmore as a Phoenix, or Skidmore's Inevitability, rather than.
Well, I will make the observation that I also have an article in search of the modern Skidmore standard that I wrote out after Mead that I feel like is going to start to take on new life again. Although, it's not entirely clear that Skidmore in 2024, once it gets applied post Loper-Bright, is going to look precisely the same as Skidmore post Mead, when it was being applied not to notice and comment regulations and not to formal adjudications, but only to less formal pronouncements by agencies. So we'll have to wait and see what happens. But, there you go.
I do
Three
want
of my articles referred to
devote,
by other people in one conversation.
I do want to devote the rest of our time to really looking at what we think Loper-Bright decided. And but before I do that, I want to just give Bridget a chance to weigh in on just how Chevron was being applied in practice right up until Thursday, if you want to say anything about that before we move on. Okay, So maybe Emily, I'm going to assign you the task of kind of explain to us, to the best of your knowledge, what does Loper-Bright hold?
So we won't know for a little while, I think but we've already said that. And that's a weasel. So I mean, I read the majority opinion as really about Chevron step 1. And I read the dissent as really about Chevron step 2. And so, I mean, I think it's more a shift, and this is kind of a continuation of just what we were talking about, Chevron as a phoenix or as an inevitable. I mean, I really wish they had gone with relentless, because then we could, reconstitute Chevron under the name of relentless deference, which just seems like really appropriate. You can't, I mean, I suspect the court intentionally deprived us of that. But I do, the court is just really putting the emphasis on step 1. And there were prior decisions, I think, that tried to do that to some extent, by saying, no, we're overruling Chevron. If it's a matter of legal interpretation, it is court interpretation all the way down. I think is really a way, again, of kind of carving off and trying to really separate the task of legal interpretation from the question of applying law to facts and the questions of policy making, which I think the majority opinion does make clear are sort of separate issues that are distinct from, or it's trying to keep distinct from, legal interpretation. Whereas the dissent, really plays up those issues, and I think plays up the reality that in hard administrative cases, the line between law and fact, or the line between law and policy, can be really blurry. And so again, I'm inclined to read it, as doing something different, but not, and more a matter of where the emphasis is placed as opposed to something else. And I think, and I'll just say, because I feel like I have to say something about the fact that they rely so heavily on the APA, because that's, my jam. And I mean, there's a certain sense in which both decisions are obviously correct, right? I mean, the APA literally says court shall interpret the law. I mean, so the majority is right that courts should interpret the law. But then, of course, the question is, well, what do you do where the law shades into fact or policy? And the APA doesn't address that. And I think the dissent is correct when it acknowledges that reality. The messiness is what the lower courts are going to have to do. And the question that I'll be asking over the next 5 or 10 years, I'm in the right job, is whether or not the lower courts hear the message, and if they begin to resolve those hard decisions in a way that puts the emphasis back on legal interpretation and maybe makes agencies a little shyer about pressing the boundaries of their statutes to reach things that maybe Congress ought to be addressing but isn't.
So Bridget, let me come to you, because I didn't get a chance in the last round as much. So Emily's saying the message to the lower courts. What do you think that is exactly? What and we know that I think there was a court decision yesterday, so they're starting to cite Loper-Bright. What is the message that lower courts that have maybe been struggling with this very complex legal regime up till Thursday? What are they supposed to do going forward?
I mean, I think the message from the majority's opinion is that they should judge, right? I mean, that the judge's role the judge should not put themselves in the passenger seat when it comes to interpreting the statute. And so I think they're looking for a more muscular form of judging, one that scrubs in on the details more. And that is a difference, right? I mean, knowing when you start a case that you have an agency on one side of the V, and that there is this concept of deference, right? Kind of does instill within a judge a certain amount of, I would expect, humility as to the agency's posture, position, explanations, statements of expertise. And I think that that's not obliterated in Loper-Bright by any means, right? There's a recognition of the value of the government's position. But I think they're calling on that judge, that lower court judge, to to not throw in the towel too soon, right? To exercise their own judgment about what statutes mean.
So open to everyone, but I wanted to introduce in the conversation the perspective of Adrian Vermeulen, who has argued that actually Loper-Bright creates a loophole to the idea of overruling Chevron that just brings in Chevron again. That he says it's his language is it contains an enormous loophole through which most, if not all, of the Chevron regime can easily fit. And the language he quotes from the majority opinion, he says, in a case involving an agency, of course, the statute's meaning may well be that the agency is authorized to exercise a degree of discretion. Congress has often enacted such statutes. So he's basically saying, yes, the name has changed, but the idea that even judges with a mindset of we're supposed to judge, they say, oh, well, but actually Congress authorized the agency to exercise discretion here. We will defer to that, is more or less the same as it always was.
That's exactly what I was talking about with respect to arbitrary and capricious review. Where they're recognizing that sometimes the best interpretation of the statute is that Congress delegated policymaking discretion or just discretionary authority to the agency, and in those instances, the role of the court is simply to figure out what the boundaries of that discretion are, confirm that those boundaries don't violate the non-delegation doctrine, and then apply the arbitrary and capricious standard, which is effectively Chevron step 2.
Harry, you want to jump in?
Well, this is Kristin's, Chevron's inevitability. I mean, and I think to Emily's point about how this will play out, the reason I think it may be a little bit unclear is that there's a lot of language in Loper-Bright saying that judges need to find the best interpretation, that there's one and only one meaning of a statute. Right? And then there's that passage that Adrian's pointing out, that Kristin's highlighting, and that says, well, sometimes the one and only and clear and best interpretation of the statute is that Congress meant for the agency. Now, we won't ever say to interpret the statute, right? Because that's incompatible with the tone and tenor of Loper-Bright and Marbury versus Madison and the APA, but it is is a conceptual possibility, and that's, I think, where there's sort of the hidden Kaiserization, if you will, within Loper-Bright. And the question is just, will lower court judges read more of it's up to me to decide entirely, or should I be open to the possibility that in some cases the best interpretation is that essentially the agency still gets to decide? I will say that if all that language was in there and there was nothing about overturning Chevron, we might well just conclude, yeah, we're really in the same world as we were before, where it will be difficult to figure out what statutes mean, and that certainly will be there. But I also think it's important to highlight what's different about actually having overturned Chevron by saying that Chevron is overturned, and not just saying all the things elsewhere in the opinion that judges should find what the meaning of the statute. It's their responsibility. And oh, by the way, sometimes that interpretation might be to let the agencies decide. By overturning it, there is, I think, another kind of Pandora's box that the court has opened up. It tries to keep it shut in a paragraph or two, but that Pandora's box is, well, what happens with all of those prior agency interpretations that courts have held in the past under Chevron? If Chevron is now overturned, what happens to them. The court says, and I think it's another source of ambiguity, really. It says it holds that prior agency actions taken under the prior interpretive regime should not be construed to be overturned at the same time that Chevron is being overturned. But I don't know how other lower courts, and then ultimately the subsequent Supreme Courts is going to take the meaning of an agency action. So I mean, in one sense, that they could be saying that a rule that had been challenged and upheld under Chevron in the past, okay, that by itself can't be reopened just because we're overturning Chevron. Or if somebody has received a license or a permit based upon some prior agency's decision and action, based upon an interpretation that had been upheld before under Chevron, that particular license and that particular permit still stands. But what it's not clear to me is what will happen with, say, somebody coming along with obtaining a new license or being denied a new license under prior interpretation, not so much an agency action, but if that interpretation was wrapped up in a prior adjudication, it's not clear that to what extent that that the new license denial or permit denial will be one that can't be a vehicle for a challenger to come forward and say, you know, that prior decision, even though it's been litigated in the past and upheld under Chevron, now court, we want you to reopen it. And with the court's decision yesterday in Corner Post too, with allowing subsequent businesses to come forward and essentially reopen the statute of limitations on challenging agency. In this case, it would be challenging agency interpretations. I think it's going to, foster a wave of additional litigation that would not have happened in all likelihood if they had just Kaiserized and kept out those three words, Chevron is overturned, from the opinion.
I make three really quick points. One is, I thought Adrian's piece was great, and I basically agree with it, but I think it's overstated, and that it's easier to get off that train. The loophole is not as big as it says, because one of the fights about Chevron has always been is an ambiguity and implicit delegation. And the strong reading of it is that the delegation is discovered in the ambiguity. It's very easy to say, given the opinion in Loper-Bright, that this category, the big loophole, is for explicit express delegations, right? Where the statute actually says, a particular word as defined by the agency, right? And there we'll ask whether the agency's definition is arbitrary and capricious, and it's pure step 2, and it's a statutory term, but there's been an explicit. And I don't know that judges will limit it to explicit or express delegations, but they certainly could. It's doable, and that may constrain the loophole. On the overruling, it's so interesting that they use the term, because if we were 1Ls in legal method learning about the difference between reversing and overruling and what it means, stare decisis and so on, we'd say, oh, they overruled Chevron. That means the bubble policy is invalid after all, right? That's the holding of Chevron. That's what it would mean to overrule Chevron. What they've done is shifted or abandoned the interpretive technique adopted in a prior opinion. And it's a little weird to call that overruling, actually. And so,
Michael, can I just interject? Yeah. Can we think of other examples of that, of essentially overruling an interpretive methodology? That seems kind of unique to me. I couldn't think of, off the top of my head, like other instances where we could put that same framework on it?
I don't have one off the top of my head. No.
Mm.
And when at least three folks so far have said that this is kind of aggressive, that it might have been milder to Kaiserize and so on. One of the things that underlines how aggressive it was actually using that terminology, right? Using that phrase, which is not a lawyer's lawyer wouldn't necessarily say they overruled it, right? It's a technically probably a technically incorrect use of that term, but it has symbolic and emotive and signaling power in a very big way. My third point, I'm not important. Those are the 2 points.
This is such a fun conversation. I wish we could go on forever. I know we're about to.
I would just say
yeah.
one thing was just it was an attempt to be prospective in its overruling. I mean, that's I think that's one way of looking at what.
Right, but that whole discussion, which you rightly highlight about, we're trying not to subject. We're trying to not reopen old cases. That was necessitated by the phrase overruling.
Exactly. Yeah. Exactly. And I think
that was walking into a punch a little.
That's going to open up a Pandora's box for some time. And we'll just have to see how the court responds to what will be, I think, a wave of litigation trying to figure out what's been overruled and what hasn't.
I was just saying, this is so fun. I wish we could go on forever. I know we're at against time, and maybe we should just do this conversation again 6 months from now or a year from now with the same group to kind of see how it's progressing. But if you'll indulge me, I just want to ask one last thing and have everyone maybe say a word on it, and we'll close. We've, I think, have a certain consensus about at least the doctrinal uncertainty, and possibly that, maybe the doctrinal reach is not that broad. But we've, I think, also maybe consensus that there's some other language in the opinion that is sort of, it goes to the symbolism of Chevron. And so I just want to maybe just go around the horn really quickly and see what people think of that. So putting aside this, very legal craftsman question of how lower courts are going to, interpret their authority under Loper-Bright, what does the stuff that, I think Cary was talking about at the beginning as well, the sort of, and Michael as well, maybe the sea change and kind of rhetoric about the administrative state generally that the Supreme Court is reinforcing in a number of decisions right now. Like, what do you make of that? What is that significance of that? Sort of a little bit independent of how courts apply this decision in their cases in the few months ahead.
I'll just say this is a court that's very suspicious of administrative power, and it's reflective in Loper-Bright. It's reflective in a number of other decisions. It's the emergence of a robust major questions doctrine. It's reflective in the Jarkizi case. It's reflective in Corner Post. This is from a doctrinal standpoint, I think, a period of a high administrative law.
I also think Congress, or the court, is really trying to send a message to Congress through the major questions doctrine, through Loper-Bright, et cetera, that it wants Congress to step up and make more of the major policy decisions for itself, resolve some of the ambiguities, at least that Congress is aware of, for itself, rather than more reflexively punting to agencies a lot of the hard choices, although it still leaves the door open for Congress to do that, so long as it does so explicitly. Because thus far, all of these cases have been decided on statutory grounds rather than constitutional ones.
But Kristin, if I could ask you a quick follow-up, what if Congress is just structurally incapable of doing that? What if what they want Congress to do is just not plausible in reality?
Well, and that's the flaw in the argument, right? But then at the same time, I suppose it raises an interesting question about, if you are the Supreme Court, do you write opinions based on how you think the three branches ought to work with one another? Or do you write opinions based on, do you just assume that Congress has to be written off as completely dysfunctional, and therefore you write the opinions assuming you're only going to have two functional branches of government? And I tend to think, at this point, I think the Supreme Court is going with the former option, how government ought to work, how the Constitution envisions that government is going to work, as opposed to just writing off Congress as a lost cause.
Emily, Bridget, take us home.
I mean, one thing that we're not talking about as much as I think maybe we should in the future is how this affects agencies and how they will operate and interpret their statutes. I mean, one thing I found really striking is, Chevron is a doctrine about courts. It's about how courts should review agency interpretations of statutes. It is not about how agencies should interpret their statute. Agencies are supposed to be figuring out what does Congress want us to do, and not what can we get away with in the courts. And I found really striking Chris Walker's study that he published in the Stanford Law Review, where he interviewed agency attorneys and found that 9 out of 10 rule drafters thought about Chevron when writing regulations. And that strikes me as wrong. They shouldn't be thinking about Chevron. They should be thinking about what does our statute mean, right? And I've seen some hand wringing about, oh, this is going to empower lawyers and get lawyers more involved in rule drafting. I just don't believe that lawyers aren't already involved in rule drafting. And for me, the question is, how are they involved and what, how are they advising? And I think they should be advising what is the best reading of the statute, not what is a permissible reading that we can defend in court. So I think this has the possibility of refocusing agencies on that. And one thing that I think is getting lost, there's a sort of, we were talking about sort of the broader atmospherics. There is like a serious extent to which this court seems to be empowering, their unitary executive, like empowering the president. There's a certain sense in which this decision goes the opposite direction, because it gives, I think, a really powerful legal tool to agency lawyers to resist political calls from the president's, from the administration, to interpret statutes in a way that will help fulfill campaign promises that are not really consistent with the statute. And so there could be a powerful extent to which this is actually a limiting effect on the ability of the president to use the administration to fulfill political aims that aren't consistent with the statutory language.
Bridget, you get the last word.
Oh boy. I mean, I think maybe foregrounded much, and that's worth sort of sneaking in here at the end, is this question of, how much upheaval we should be expecting to the regulatory state overall. And I say that with respect not just to, the overturning of Chevron, but also, what we got from in Corner Post, for example. So I think it's a little bit, I'm still sort of thinking this through, but you hear all the time, particularly from the business community, they want stability, they want reliability, they want regulatory frameworks that they can plan around, do 10, 20 years of capital planning based on. And these decisions guarantee almost the opposite, right? It guarantees a level of flex and instability and a period of settlement that could take, I mean, I don't think it's naive to say multiple decades to sort of shake out, what the new rules of the road for the regulatory state are going to be. Again, not just because of Loper Bright, but because of this larger sort of administratively skeptical moment that we're in. And I also find myself so that's sort of at odds with a certain number of incentives. I'm also struck by, who pays the price in periods of instability, and, it's, in my experience, it's generally not the more moneyed interests. So, it's like, who's losing, as, if the Supreme Court's project is to put the administrative state on what it views as its proper course, and to put judges in their proper role, and maybe even to throw a little hip check at Congress and say, hey guys, get in the game here. That churn, that, maybe multi-decades long churn, is just going to be a period of instability for a lot of people, both, you know, the sort of what we think of as the sort of moneyed special interests and people who are just subject to the millions and millions of ways in which federal regulation, you know, intersects our lives in ways that we can't even perceive, right? It's so below the surface, it's so just woven into the fabric of life. So I don't know. I guess that's why I kind of come at this from the perspective of, you know, we have a lot of work to do in the academy to keep an eye on this and to kind of understand what we're seeing and to do our best to synthesize and kind of send out signals, in part so that the public can, you know, hopefully be aware of what's happening in their government. So, I mean, I just don't think the stakes could be higher. I'm also not a pessimistic person. I'm an optimistic person. I'm also an incrementalist, but this has been a lot. I mean, this has been a big, you know, couple week span for administrative law, and I think we just have a lot of work to do.
I can't think of a better way to conclude, but Michael wants to put in one last word, so we'll see if he can.
I wanted to just
meet that bar.
Okay, I apologize in advance if I fall short, but I wanted to make two big idea points, totally riffing off of or stemming from Kristin's 2 points. One is this choice between the kind of official version, normatively preferable understanding of how Congress works versus the descriptively accurate one of dysfunction. That is more generally true of the basis on which this court decides cases and writes about governmental institutions. It tends to ignore facts on the ground, not all the time, but tends to ignore facts on the ground in favor of the official normatively preferable version. And that is emphatically true of its understanding of the process of statutory interpretation in Loper-Bright, right? That there's a best reading, that any judge will reach the same best reading, and so on and so forth. It has the normative vision, which one could deride as the junior high school civics vision, just has a powerful hold on them. And they're making law on the basis of it. And the second thing was the idea that this is directed at Congress. To state it the most boldly way, the current court has one idea, okay? One idea in administrative law. It's that Congress overdelegates. And almost every single major doctrine it's developed or abandoned can be explained by an underlying concern with congressional delegation to agencies. So that's most obvious in the non-delegation cases, right? But, you know, they never quite get there, though they edge closer and closer to a real non-delegation doctrine. But it underlies major question doctrine. It absolutely underlies Loper-Bright, as Kristin just said. And we could go through the whole list of them. You know, a lot of stuff that they call separation of powers is actually about non-delegation. It's Congress not doing its job. It's endless, right? So you could almost back every decision it makes back up to non-delegation.
The truth is, there's no good place to stop. This is such a fun conversation. We could keep going. I will arbitrarily and capriciously bring an end to the conversation now, but with a deep sense of gratitude to all of you for spending this time, to Cary and the Penn Program and Regulation for sponsoring this series, the Law and Governance series. And we should keep the conversation going. We should have the same conversation maybe 6 months from now and see how it goes. But for today, we'll bring it close. Thank you all. And maybe this is the new way we'll do this series from now on, this video version.